Fourth Amendment violation stuff and causation analysis for exclusionary rule. All right, so let's just try this then. This is called the inevitable discovery doctrine today. The demands of the Fourth Amendment, Nix and Murray, and the disagreements among the federal circuits. Introduction. The exclusionary rule and its exceptions. This comment explores the most recently developed exception to the exclusionary rule, the inevitable discovery doctrine. Before discussing this exception, it is helpful to briefly explain the exclusionary rule. The judiciary created exclusionary rule prohibits the state from using evidence obtained through police misconduct. Police misconduct includes the violation of a criminal defendant's Fourth, Fifth, or Sixth Amendment rights. Generally, the exclusionary rule operates by excluding all illegally obtained evidence from being introduced in a criminal trial, whether obtained directly as primary evidence or indirectly, derivative or secondary evidence from police misconduct. The distinction between primary and derivative evidence can be dispositive in determining whether an exception to the exclusionary rule will be applied, depending on the jurisdiction and the situation presented. The rationale behind the exclusionary rule is deterrence. If the government knows it will not be able to use evidence gained in violation of a defendant's rights, it will be less likely to violate those rights. But while the rule is quite effective in punishing police misconduct, it has a high cost to society. It lets the guilty go unpunished merely because the police blundered. For nearly 75 years, the Supreme Court did not apply the exclusionary rule to the states. However, in 1961, the Supreme Court, under the theory of incorporation by the 14th Amendment, did just that. Since then, the rule has been subject to a great deal of criticism. Much of the criticism comes from state law enforcement. However, some of the most disparaging attacks on this judge-made doctrine have come from new members of the Supreme Court. As more justices have reorganized to the rule's unpopularity and its recognized the rule's unpopularity and its quote high social costs of letting persons obviously guilty go unpunished for their crimes, the Supreme Court has carved out some exceptions to the exclusionary rule. These exceptions are generally appropriate in situations where application of the exclusionary rule would fail to achieve its deterrence purpose. The first exception the court developed is the independent source doctrine. This exception permits the introduction of evidence in a criminal prosecution despite the fact it was initially discovered during or as a consequence of police misconduct, provided the state can prove that the evidence was later obtained from independent lawful activities untainted by the initial illegality. For example, where an unlawful warrantless search has given the police knowledge of facts A, B, and C, but fact C has also been learned by other means, fact C will be admissible at trial because it was derived from an independent source. Suppressing fact C under the exclusionary rule would be unfair to the state because that would go beyond the rule's deterrent purpose. Quote, when the challenged evidence has an independent source, exclusion of such evidence would put the police in a worse position than they would have been absent any error or violation. Close quote. Attenuation of the taint is a second exception to the exclusionary rule. This exception keeps certain evidence from being suppressed if the state can prove that the tainted quality of the evidence was sufficiently purged by attenuation, or distance, between the misconduct from which it was derived. In a sense, this exception is the criminal procedure version of the tort doctrine of proximate cause. The court in Wong Sun v. United States established this exceptions test to be, quote, whether granting establishment of the primary illegality, evidence to which an instant objection is made, has been come at some exploitation of that illegality, or instead by a means sufficiently distinguishable to be purged of primary taint, end quote. An intervening act of free will is a good example of attenuation, sufficient to break the causal chain between evidence and police misconduct. In Wong Sun, the court found that the fact that the defendant was released on his own recognizance after the illegal arrest, but later returned to the police station to confess, removed any taint from that confession. The third and most recent exception to the exclusionary rule, the inevitable discovery doctrine, is best understood as, quote, an extrapolation from the independent source doctrine. Since the taint of evidence would be admissible if in fact discovered through an independent source, it should be admissible if it inevitably would have been discovered, close quote. Thus, the inevitable discovery doctrine is like a speculative or hypothetical version of the independent source doctrine. This comment begins the analysis of the inevitable discovery doctrine by reviewing Robert Anthony Williams' cases, where the Supreme Court suggested and then adopted the doctrine. The comment then explains two interrelated areas in which lower courts have conflicted with each other and arguably interpreted the doctrine beyond the original intention of the Supreme Court. The split in the lower courts includes decisions which expanded as well as refused to expand the doctrine's application to either 1, admit primary evidence, or 2, avoid the warrant requirement of the Fourth Amendment. The comment reviews each of these two expansions separately and stresses their erosive effects on the exclusionary rule and the Fourth Amendment. A brief explanation of the active pursuit doctrine, a requirement which attempts to solve the erosion problem caused by the aforementioned expansions, follows. Lastly, the comment concludes with an examination of the need for the Supreme Court to unify its lower courts and expressly adopt certain limitations to the inevitable discovery doctrine. 2. The adoption of the inevitable discovery doctrine, the Williams cases. The Supreme Court adopted the inevitable discovery exception when dealing with the monstrous crime of Robert Anthony Williams, a supposedly religious man who kidnapped and murdered a 10-year-old girl on Christmas Eve, 1968. The controversy of the Williams cases stems from the admission of certain incriminating statements made as a result of police misconduct in Williams' 1969 trial. The misconduct consisted of unlawful conversations between police officer Detective Lerming and Williams, during which Williams' attorney was not present, even though Williams had been arraigned and had retained counsel by that time. In this conversation, popularly known as the, quote, Christian burial speech, close quote, Detective Lerming played to Williams' religious sympathies by pleading to him to reveal the body's location in light of an imminent snowstorm, so her parents could have closure and provide the girl a proper burial as soon as possible. Lerming was successful in obtaining the information he sought from Williams and subsequently found the victim's body because of that information. At trial, Williams argued that the exclusionary rule should preclude the jury from learning of the incriminating statements obtained as a result of the Christian burial speech. Though the trial judge was not convinced of the need to suppress that evidence, Williams' arguments eventually prevailed before the United States Supreme Court. In his habeas corpus appeal, Brewer v. Williams, in Brewer, the court held that the evidence in question had been improperly admitted at trial because it violated Williams' Sixth Amendment right to counsel. It is important to note that the court closely divided its ruling, and that the ruling was met with a great deal of unpopularity, many naturally believing that Robert Anthony Williams should be brought to justice. Not surprisingly, the holding in Brewer incited further debate and controversy over the societal cost and effectiveness of the exclusionary rule. For those who demanded a conviction, if there was a more saving grace to Brewer's court's action, it was found in the opinion's 12th footnote. The footnote indicated that although the exclusionary rule precluded Williams' incriminating statements from being introduced into evidence at a second trial, evidence of the body's location and condition, quote, might well be admissible on the theory that the body would have been discovered in any event, even had incriminating statements not been elicited from Williams, end quote. In fact, at the time Williams' unlawfully obtained statement led the police to the culvert ditch which contained the victim's body, there was an ongoing independent search that was unaware of Williams' assistance, no more than 2.5 miles from that ditch. Arguably, this independent search party would have inevitably found the body without Williams' help. Thus, the footnote in Brewer paved the way for the adoption of the inevitable discovery exception. Later, in Nix v. Williams, the Supreme Court affirmed the admission of evidence of the body's location and condition in Williams' second trial conviction. The Nix court found that there was sufficient evidence that the independent ongoing search would have inevitably discovered the body, regardless of the Christian burial speech. The Nix ruling marked the Supreme Court's official adoption of the inevitable discovery exception. The court's adoption of the inevitable discovery exception represents a recognition that society's interest in punishing criminals should not be less important than its interest in deterring police misconduct. The court realized that without the inevitable discovery exception, there would be certain situations, like the Robert Anthony Williams case, when the exclusionary rule would do society a disservice, unfairly tipping the balance interest in favor of setting an acknowledged criminal free. Adoption of the inevitable discovery exception seeks to fairly balance the scales of justice, that is, quote, the interest of society in deterring police misconduct and the public interest in having juries receive all probative evidence of a crime are properly balanced by putting the police in the same, not a worse position than they would have been if no police error or misconduct had occurred. The court reasoned that since the rationale behind the exclusionary rule is that, quote, the prosecution is not to be in a better position than it would have been if no illegality had transpired, close quote, it follows that, open quote, if the prosecution can establish by a preponderance of the evidence that the information ultimately or inevitably would have been discovered by lawful means, then the deterrence rationale has so little basis that the evidence should be received. Anything less would reject logic, experience, and common sense, close quote. During arguments of the Nix case, the court was asked to impose a requirement, in addition to the requirement of proving inevitability, that the state must also prove an absence of bad faith before the inevitable discovery doctrine could be utilized. The reasoning behind this proposed limitation was that, quote, if an absence of bad faith requirement was not imposed, the temptation to risk deliberate violations of the defendant's constitutional rights would be too great, and the deterrence effect of the exclusionary rule reduced too far, end quote. However, the majority of the court flatly rejected this good faith requirement, seeing it as unnecessary and reasoned that, quote, if a police officer who is faced with the opportunity to obtain evidence illegally will rarely, if ever, be in a position to calculate whether the evidence sought would be inevitably discovered, close quote. And even if an officer were in such a position, open quote, he will try to avoid engaging in any questionable practice because in that situation, there will be little to gain from any dubious shortcuts to obtain any evidence, close quote. Again, with the concern that society's interest in justice not be given less weight than the rights of criminal defendants, something the inevitable discovery exception has come to stand for, the court concluded that, open quote, the societal costs of the exclusionary rule far outweigh any possible benefits to deterrence that a good faith requirement might produce, close quote. 2. The primary/derivative evidence distinction. It is unclear if the Nix court, in adopting the inevitable discovery doctrine, meant to restrict the application of that exception to derivative evidence only. Unfortunately, nowhere in this opinion does the court speak to the issue of whether the exception's scope would allow the state to admit primary evidence in a criminal prosecution. Largely because of this omission, the lower courts have been split on the issue since. Since Nix. The following discussion explores the split and compares the opposing views. So we'll read footnote 18 real quick. Certain facts in both of Williams' Supreme Court cases indicated that the court probably did not mean for the exception's scope to go beyond derivative evidence. First, the only evidence covered by the newly adopted exception in Nix was the location and condition of the victim's body. That kind of evidence is derivative in nature, as it was a byproduct of the original incriminating statements obtained by police misconduct. Second, those incriminating statements which constituted primary evidence since they were the direct result of the misconduct were never suggested as potentially permissible under the exception that the Brewer footnote foresaw. The footnote only indicated that the derivative evidence, the body's location and condition, would have been admissible in Williams' second trial. See Brewer v. Williams, U.S. Supreme Court, 77 case. All right. So, A, the minority view, limiting the exception to derivative evidence only. The District of Columbia is one of the lower courts that sees the Nix decision as explicitly limiting the inevitable discovery doctrine to derivative evidence only. Recall, derivative evidence is obtained indirectly, whereas primary evidence is obtained directly from police misconduct. The D.C. Court explained why it believes this exception should not include primary evidence in the case U.S. versus $639,558 in U.S. currency. In U.S. currency, a bag of Christopher Todd Belchford, a man suspected of being a drug courier, was searched illegally without a warrant. The bag was found to contain over $600,000 thought to be traceable to an illegal drug exchange. The money was primary evidence as it was the direct result of the police misconduct. At trial, Bleachfield was successful in arguing that the evidence should be suppressed under the exclusionary rule. On appeal, the government argued that the motion to suppress was incorrectly granted because in Belchfield's situation, the government inevitably would have been legally empowered to search the bag without a warrant under the authority of an administrative inventory search, and thus the inevitable discovery exception applied. The D.C. Circuit Court rejected this government's argument. The court held that the inevitable discovery exception allows for introduction of derivative evidence only. The money found by the illegal search being primary evidence was thus not covered by the exception. The D.C. Circuit in U.S. currency argued that the Supreme Court never meant for primary evidence to be covered by the inevitable discovery doctrine. The court stated that, quote, the reasoning of Nix in support of the inevitable discovery exception relied heavily on the derivative nature of evidence, and the Supreme Court stated, and the Supreme Court's statement about not putting the government in a worse position because of police misconduct was limited to that subject alone. To support this analysis, the D.C. Circuit focused on the key language in Nix that was written primarily to calm fears of the inevitable discovery exception might be abused by clever, overzealous police. The court reasoned that this language, which states there is little chance for abuse of the inevitable discovery doctrine because a police officer, quote, will rarely if ever be in a position to calculate whether the evidence sought would be inevitably discovered, close quote, only makes sense if you assume the Nix court was thinking of derivative evidence and not primary evidence. The following hypothetical illustrates the D.C. Circuit's logic. Suppose a police officer is 1. Knowledgeable about his department's investigatory procedures, and 2. Impatient to get his hands on some incriminating evidence. In this situation, the officer could easily calculate whether he could go ahead and obtain that evidence illegally without the risk of this primary evidence being inadmissible, because the officer would know if the evidence would be inevitably obtained anyway under the inventory procedures. In this hypothetical, the calculation is easy because the officer is dealing with primary evidence, something immediately known and obtained directly after the misconduct. However, in dealing with derivative evidence, which is an unknown indirect future byproduct, it is nearly impossible to calculate its potential admissibility because the officer can neither know 1. To what end the derivative evidence will lead, nor 2. If there is already another line of investigation working towards that same end. This impossibility of calculation was certainly true in Robert Anthony Williams' cases. There, Detective Lemming could not have possibly calculated that his Christian burial speech would obtain for him the condition and location of the body, nor that the searchers were coincidentally looking for the body in the same area, determinations which would both be necessary to conclude that the evidence would be inevitably discovered and thus admissible. Weird. We might have a actually turn on. Weird. In the U.S. currency, not only was the calculation quite possible because the evidence at issue was primary in nature and thus amenable to that sort of estimation, but the calculation was in fact made by the government. The D.C. Circuit Court noted that U.S. Assistant Attorney Robert Andre, who was called on by officers that wanted to get into Bloomfield's bag, quote, told the officers that a warrant was not required, citing the eventual inventory of the luggage to explain why he so advised them. What better way to illustrate the D.C. Circuit Court's fear of the great potential for abuse of an inevitable discovery exception than with the very facts in U.S. currency, where clever and impatient officers calculated the admissibility of primary evidence to justify police misconduct. This court summed up its reasoning as follows. Oh, that's what happened. In the evidence stemming from the violation is nevertheless admissible on the basis that the bags inevitably would have been opened when they were inventoried, the practical consequence is apparent. In the vast amount of cases, there would be no incentive whatever for police to go to the trouble of seeking a warrant, or should we add, of waiting for a lawful inventory to occur during normal processing. The police could readily make this assessment on their own. Contrary to what the Nix supposed, they would almost invariably be in a better position to calculate whether the evidence would inevitably be discovered because they would know the inventory procedures that were in place in their department. The Ninth Circuit is another court which has read Nix as limiting the scope of the inevitable discovery doctrine to derivative evidence, and its recent opinion, United States v. Polanco, is illustrative. In that case, Miguel Polanco was arrested and questioned by the LA Police Drug Squad, who had caught him selling controlled substances on a street corner. Polanco made certain inculpatory statements during this questioning. However, the drug squad had neglected to read him his Miranda rights first. The unconstitutional inculpatory statements led police to obtain Polanco's criminal record, which helped them to prepare a stronger case against the defendants at trial. At trial, the state sought to admit both the inculpatory statements and Polanco's criminal record. The trial judge allowed admission of this evidence under the inevitable discovery doctrine, despite Polanco's motion to suppress the evidence. On appeal, the Ninth Circuit held that the trial judge was in error for allowing the primary evidence, the inculpatory statements, to be admitted in a criminal trial. Under the inevitable discovery doctrine. But it was correct in admitting the criminal record, since that was derivative evidence. The Ninth Circuit made it clear that according to its understanding of Nix, the inevitable discovery exception only, quote, allows for the admission of evidence derived from the defendant's unconstitutional inculpatory statement, provided the evidence would have inevitably been discovered by an independent means, close quote. But the, quote, doctrine does not, however, allow the admission of unconstitutional inculpatory statement itself, close quote. Though the Ninth and D.C. Circuit's reasoning in limiting the inevitable discovery doctrine to derivative evidence is consistent with what seems to be the Supreme Court's intent in Nix, it does not represent the majority view among the circuits. The D.C. Circuit admitted in U.S. Currency that, quote, several other courts of appeal, when faced with inevitable discovery claims, have either rejected or ignored any distinction between primary and derivative evidence, close quote. In expressing its frustration with those other circuits, the D.C. Court concluded that, open quote, whatever one may think of the distinction, the fact remains that Nix drew it, and did so for the purpose of demonstrating the deterrent effects of the exclusionary rule would not be lessened, close quote. And that was from the U.S. Currency case. All right, well, we'll go ahead and read part 2 and 3 coming up in the next video, or part B. The majority view will be next, actually.